Someone requested us to explain the Places of Worship Act, 1991. And others asked us if the act was not tilted against the Hindus. Here is our response to both. We, Hindus, were thrilled when Ram Janmabhoomi verdict came in our favor. Ram Janmabhoomi was on the manifesto of one political party. Another party was opposed to it. So much so that the government formed by it opened fire on the Karsevaks gathered there and killed scores of them on 2nd November 1990. So did the weight thrown behind it by one political party. When other parties opposed it, won us Ram Janmabhoomi? Obviously not. Then how can we win our battles for the Kashi Vishwanath and Mathura Krishna Janmabhoomi temples with the help of political parties? Well, we cannot. We must win them via law court verdicts, the way we won the Ram Janmabhoomi case. But then, the Places of Worship Act, 1991 is an obstacle in that path. If so, how wasn't that act an obstacle in the path of Ram Janmabhoomi verdict? Well, simply because the Ram Janmabhoomi case was under litigation much before this act came into being. Ram Janmabhoomi was a matter of disputed land since 1885, when Mahant Raghubar Das filed suit in Faizabad court claiming Ram Janmasthan. Several suits followed this, and the matter remained under litigation till the final SC verdict. The act did not have the legal muscle to stop this process. Alright then, what is Places of Worship Act? It is an act that freezes the status of any place of worship as it existed on 15 August 1947. By the way, you may wonder, as we do, about the selection of 15 August 1947 as the freeze date. Had the British till that date settled all the places of worship issues? If not, why was this date chosen? How does this act affect Hindus? India has been subject to invasion for several centuries. During these invasions, several thousands of temples were destroyed and demolished to build churches and mosques in their places or on top of them. The Places of Worship Act, 1991 prevents Hindus from taking legal action to reclaim those demolished and built over temples. Given this, are the Hindus fated to lose claims over temples forever? Yes, quite so. Unless the law is declared unconstitutional and repealed, Hindus shall not be able to lay claims on any of their demolished or built over mandir. Then, what should be our future course of action to get back our mandir? First and foremost, there is already a petition against the Places of Worship Act, 1991 in the Supreme Court. This should be pursued passionately, competently, and persistently. Secondly, one needs to realize that only when an average devotee in the country raises his voice against the act, that this demand will appear on the political manifestos. Keeping this in mind, winning back our temples needs to be turned into a mass movement. It also needs to be backed by serious political lobbying. The third most important factor in Ram Janmabhoomi case was the archaeological evidence. Once the archaeological evidence shows the remains of a mandir underneath any place of worship, it helps the judiciary to take the right decision. Hence all the prima facie evidence such as ancient documents, carvings, and so on needs to be collected and presented to the authorities concerned to demand archaeological excavations. Ironically, despite the fact that archaeological evidence played such a major role in Ram Janmabhoomi case, the Allahabad High Court has stayed the archaeological survey in the Kashi Vishwanath temple in September 2021. This decision needs to be legally challenged. All in all, if we wish to reclaim our temples, we Hindus need to do all the above and, more particularly, without let up, keep raising our voices for their possession. There needs to be a feeling of community between all the Hindus, irrespective geographical and political affiliations, so that sufficient pressure is built on the political parties to repeal this repugnant act.